Good afternoon, everyone. I'm Trent Taylor, and welcome to our webinar, our latest quarterly webinar. And I will be your host for today, and this is the Purple Raspberry Bourbon edition of our quarterly webinar. We're going to go ahead and get started. We have a lot to cover, and this is today's lineup. This is our illustrious panel, and we're very happy to welcome back Alicia O'Brien, who couldn't join us for our last one because she had a conflict, but she's back with us for this one to talk about Prop 65. A quick mention of today's theme, which I understand some folks reached out and they were sort of scratching their head a little bit about why we called it the Purple Raspberry Bourbon Edition. And here's why. We like to have fun with these, as you probably know, and we look for themes, typically a little bit more outside the box themes. And we noted, first of all, the National Bourbon Day was June 14th. So that's good. I think most of us like bourbon or whiskey. I'm a good Tennessee boy, so we typically call it whiskey, but bourbon works too. And then some of our other folks noted that there is a certain iconic late pop singer associated with the color purple who was born on June 7th, yesterday. So we sort of bounced around the ideas for which of these themes might work, and we decided to combine them into one theme. So that's what we have done today. And I'll say that neither of the themes resonated with all of our crew, as some decided to ignore our theme altogether and sort of create their own theme. But we're a big tent here, so I suppose that is acceptable. And you note we have, this is our other theme, which includes doves and little red corvettes and purple clouds with purple rain coming from them, and a mine with, it looks like maybe a raspberry beret. Okay, so here is our road map for today. This is pretty typical. We've switched up the order a little bit. I'm going to talk about trends from 30,000 feet to begin with here in just a moment. Jenny's going to talk about product labeling litigation. Kate and Royce will handle regulatory. A new topic, NAD decisions. Jocelyn is going to cover those. Food and beverage labeling litigation, Ben will cover. Maggie will once again cover alcohol. And Alicia will finish us off with Prop 65. And as always, if you have any questions at all, feel free to submit them, and we will be happy to try to answer them either during the program or after the program. And that holds true even if you think about a question later on, tomorrow, next week, next month. Feel free to reach out to us, and we're happy to sort of help you and talk through any questions that you may have. Okay, so consistent with our theme, here are a few of my favorites with regard to the bourbon theme. There's a bourbon cocktail I like called the Belvedere. It's like a Negroni, except it includes bourbon. And it's bourbon, Campari, and vermouth. I will often omit the vermouth and just have bourbon and Campari. I'm not sure what that's called, but it's delicious as well. And then for my favorite song by a certain iconic late singer whose birthday is June 7th, I choose When Doves Cry. And that was a song, one of the first songs I heard by the purple one, and one of my favorites. It was sort of showed the darker side, his darker side, and it was just sort of weird, and it was delightfully weird, I would say. So those are my favorites. But let's get into the actual content of what we're going to be talking about today. And the trends. And as you know, as we do this, one of the things that we do is we track all labeling and, frankly, sales practice litigation class actions that have been filed. And I think it allows us to provide some insights with the raw numbers. So it's not just, I have a hunch that this might be big. We can actually look at the raw numbers. So there have been 170 new labeling class actions filed since our last webinar. 60 of those food and beverage, 64 non-food and beverage products, and 44 relate to sales practices. Now, I keep thinking that these class actions have to slow down at some point, but they just keep increasing. And you can look back at our other webinars and see every single time I do this, it's an increase from the preceding quarter. So it's a 22% increase from the last time we measured, a 41% increase from the fourth quarter of 2021, and a 107% increase from the third quarter of 2021. And this is the fastest pace that we've seen yet. And this is particularly significant because, as I'm going to note here in just a moment, Spencer Sheehan, who had been filing a lot of these over the last year, his filings have slowed down fairly dramatically. So these are other players who are getting involved. One other thing that I'll mention, sales practice litigation has increased 175% from the last time we measured. There are a ton of those, and I'm going to mention that a little bit more later. All right, where are these class actions being filed? Here's a quick graph. As you may recall, last year we were talking about how New York and Illinois had usurped California as the desired location for plaintiffs' counsels to file these class actions. That's not true anymore. California is dwarfing the others. And here is the actual raw numbers. As you can see, 66 of those were filed in California. And filings in New York and Illinois have sharply declined from last quarter. Now, the other thing that I think is noteworthy is that there is more variability in forums where cases were filed than in the last few quarters. So we're seeing them in a lot more jurisdictions, not just sort of just in California or just in New York or Illinois. We saw everywhere from Tennessee to Arkansas State Court to Massachusetts to New Jersey, Florida to Ohio, really Wisconsin, and several in the Western District of Washington. So a number sort of all over the place, and that's sort of an interesting trend to watch. Who is filing these labeling class actions? And here's sort of a graph. Bursar and Fisher, they're the ones who have taken the lead lately, usurping Spencer Sheehan. And here are the raw numbers, 22 for Bursar Fisher, 15 for Sheehan, which is a dramatic decrease than what he has been doing over the last few quarters. And, conversely, Bursar Fisher's pace is significantly higher than they have been in some time. And for those who are familiar with Bursar and Fisher, they're a bigger and I would say arguably more well-known plaintiffs firm than Spencer Sheehan, but they've sort of adopted Sheehan's model or his tactic of filing lots of class actions. And you could argue that this poses a greater challenge for defendants than some of Sheehan's suits that have not had a lot of success as of yet. What products are being targeted by class action labeling suits? And the short answer is personal care products. And here are the actual raw numbers. The personal care products, that includes cosmetics, deodorants, lip balm, and shave gels, 15 of those. And that's even without some of the benzene cases, which have dried up. Also to note, dietary supplements, 11 of those were filed. And that number is going up, and it's going to go up even more because of something that happened yesterday. And I will not leave you hanging on that too long. I'm going to talk about that here in just a moment. The significance of what types of products are being targeted. Benzene cases are way down, and you're going to see why that is here in just a moment. But litigation targeting personal care products, cough and cold medicine, pain patches continue. And then fast food, that's another big one to watch. And Ben's going to talk about that a little bit more in a few moments. But this is not just PFAS, which relates sort of to fast food packaging, but it also involves the size of the fast food, like how big the burger is, as well as sales practices like the fees charged for delivery and mobile app issues. And so those are new targets, and those are ones to watch closely going forward. What claims are being targeted? PFAS, as I mentioned, is a big one, and that's something that I know that both Ben and Jenny are going to talk about to a certain extent. Here are the raw numbers. The ingredient ones, there had been a significant decrease from last quarter, and that's largely due to Sheehan not filing as many, but the PFAS cases are way up. And also the incorrect nutritional information. That's sort of a sleeper category. That this is also a significant increase. And there are 3 or so plaintiff firms that are filing class actions exclusively in this area relating to calories or sodium or protein. So that's something else to watch. So let's go crazy with some recent settlements. I think it's always good to know what is happening out there on the settlement front. And here we just sort of list a few. I'm not going to go through all of them. The bottom 2 here, the Procter & Gamble and the Johnson & Johnson aerosol sunscreen, those are the benzene MDLs. And the terms have not been released for the top one, but for the bottom one, 4.85 million minimum settlement value. So these settled very early. As you recall, the last few of these, we've been talking about how many of these cases have been filed, but they haven't gone very far yet. And they have reached what looks like a global settlement for both of those MDLs. So that's interesting and something noteworthy, I think. Here are some other ones to note. I know that this top one, the Godiva chocolate one, that involves the Geographic claim that Ben will talk about more generally a little bit later. I think the Fair Life one is significant. That's a greenwashing claim, and that's a fairly big settlement there of $21 million that has now been preliminary approved. So that result may spur additional greenwashing claims going forward. So that is one to watch. Here are a couple more recent settlements, flushable wipes involving 20 million. And then this bottom one I think is interesting. It's a subpar warranty replacement products, 95 million. That's a big number. And that sort of dovetails into the sales practice litigation that is something that we're keeping a close eye on. And I think that big number exemplifies why sales practice litigation is heating up, because there is big money involved in those type of suits. A quick scorecard check, and I don't want to get too much into these, but I did want to note that we try to keep track of the motions to dismiss and motions for summary judgment that were granted and denied over the last quarter. And this is a really good record for defendants. 14 cases in which a motion to dismiss or a motion for summary judgment was granted against only 8 denials. Now, some of these are mixed, and I had to put them in either one category or the other, so I tried to figure out, was it mostly granted or mostly denied? And here are some of the cases that were at issue there. But this is a really good record for defendants, and I'm sure most of us would take that any day of the week to have almost a 2-to-1 advantage for grants of these motions versus denials. And once again, class certification rulings, not as many of those. Record of 3 grants and 2 denials. Not awful, but not great either. I think it's significant. It's still often a coin flip if you get past the motion to dismiss stage, whether a class certification will be granted or denied. One thing I will note is that it's, at least with regard to this very small sample, it's New York courts that are granting class certification, while California courts are mostly denying them. I alluded to this earlier, and this is a verdict in a class trial, and this is a big deal. We just got word late yesterday about this. As most of you know, it's rare for a class action to actually go to trial. This one did, and it came down with a verdict of what we think will be about $135 million. And this is applying the compensatory damages was only $1.5 million. But the court has indicated that it will be applying a statutory penalty of at least $50 to each separate sale. And when you do the math, I'm told it comes out to approximately $135 million. And this is why so many defendants are worried about going to trial, these statutory penalties. And they're often not applied, but they were here. And, in my understanding is this is not some sort of fly-by-night manufacturer, that there's at least some good science supporting the claims at issue. And this was only one class. There's 7 other state classes that have been certified and will presumably go to trial next. So what does this mean? I think it means that we can expect more suits against dietary supplement makers. My takeaways before I hand it over to Jenny, another record for filings this quarter, still going up. Will that fever ever break? Sales practice litigation is delirious, deliriously hot, and will likely continue. That's something to watch very closely. PFAS is very, very hot as well. Sheehan is not filing as many cases, but Bursar and Fisher has black. And once again, the cases are being filed mostly in California. One final note, Jenny, Frank Talbot, and I did a sales practices litigation webinar about 2 weeks ago about dark patterns, right to repair, hidden fees, automatic renewals, and other sales practices. And I'm not going to go into the sales practice litigation here because we've already done it and a lot more to tell because we felt it deserved its own webinar. And here is a link where you can go and watch a replay and get the slides from that webinar, or you can just go to the McGuireWoods website. So with that, I'm going to turn it over to Jenny.
Thanks, Trent. Good afternoon, everybody. I'm Jenny Price. I'm here in our Richmond office, and I'm going to be talking about product labeling litigation. But before I get into that, on theme, I'm going to tell you guys my favorites, and I'm the contrarian today. I actually don't drink bourbon. I know that's probably, I should keep that hush-hush, but especially with how many lawyers love their bourbon. But I'm a red wine girl, so that's a bottle of my favorite red wine from Napa Valley. And I also am being a contrarian on the artist theme rather than choosing a song by the artist of the hour. My favorite 80s artist is iconic artist whose my favorite album is The Immaculate Collection. So that's what I think of when I think of the 80s. And I'm sorry, Trent, that I did not pick a song from one of your favorite artists. With that, we'll move into product labeling cases. So we talk a lot about motions to dismiss on this webinar, and for good reason. They are, critical pleadings in product labeling cases. They can either, get rid of your entire case or significantly streamline the case. They're really important in class action product litigation. So I'm going to talk to you about 3 different motions to dismiss, 2 of which were denied and 1 of which was granted. The first is the in-re StubHub refund litigation out of the Northern District of California. This was actually a motion to dismiss and also a motion to compel arbitration that was being renewed by StubHub in a nationwide class action where the allegations were that StubHub wrongfully changed policies for refunds on cancellations or rescheduled shows due to COVID-19. The allegation was that, or is that, StubHub was originally offering cash refunds for canceled events, and they switched their policy to credits for canceled events. Originally, in the motion to compel, the court had granted arbitration or granted, the motion to compel arbitration to the named plaintiffs who had purchased tickets on StubHub's website, but saying that they were on constructive notice about the arbitration provision. But there were 8 plaintiffs that had purchased tickets on StubHub's mobile site. And the court, again, denied compelling arbitration as to those 8 plaintiffs, saying that StubHub had failed to meet its burden to establish those plaintiffs had entered into an agreement to arbitrate. It wasn't clear, according to the court, that either on the sign-in or check-in page that there was an adequate disclosure of an agreement to arbitrate, and also the court found that the user agreement to use the mobile site was not sufficient to put the plaintiffs on notice about an arbitration provision. The court also denied the motion to dismiss. StubHub had made arguments based on standing, reliance, and a failure to sufficiently plead a CLRA claim. That was all denied. So this case will be moving forward in some capacity in the Northern District of California. And, it'll be one that we will continue to watch. This is also one that, we talked about in our sales practices webinar a few weeks ago, and had, more cases like that on that webinar. The next case I'm going to talk to you guys about is a greenwashing case. And this will be one of the themes that I talk about throughout my presentation today is greenwashing. So the White versus Kroger Company, this is allegation that Fruit of the Earth, which is sold by the Kroger Company as its house brand, were allegedly misleading consumers when they labeled their sunscreen reef friendly, when in fact they are alleging that it contained ingredients that would be harmful to reefs. And the primary arguments that were brought in the motion to dismiss, which was ultimately denied, were puffery, one that we talked about. That's a common basis for a motion to dismiss that we talked about a lot on our last webinar. So that was one basis. They also had a Rule 9b failure to allege with particularity, fraud allegations. And then their other argument, which I thought was really interesting too, was a primary jurisdiction argument. And the primary jurisdiction argument was focused on legislation that had not yet been enacted. So apparently there's pending legislation before Congress that if it passes, will result in the FDA apparently developing regulations that may govern sunscreen ingredients and how they can be represented as far as reef health. And the court, in denying the motion to dismiss on that basis, had said that the possibility of primary jurisdiction at this point was too remote since the legislation had not passed. And so it didn't warrant dismissal on that basis. But it is interesting concept, and it's something that should definitely be watched as far as that legislation and the regulations that may develop from that. And then finally, on the motion to dismiss front, we're going to talk about the Allbirds case, which is out of the Southern District of New York. That is a motion to dismiss that was granted, and it was the second time a motion to dismiss had been granted in this case, and so the court did not give the plaintiffs leave to amend here. One other aspect that I will highlight from this case is that, one, they argued again for puffery and won on puffery, but they also, the plaintiff had cited to several documents in her complaint. And the court used those documents. One was from PETA. Well, I guess let me back up just a little bit. The allegation against Allbirds here was that that Allbirds markets, labels, and sells shoes made of wool, and that they advertise that their products are, sustainable. Sustainability meets style, low carbon footprint, environmentally friendly, made with sustainable wool, reversing climate change, and highlighting sustainable practices. This is also a really hot topic in the product world, and another example of a greenwashing case that's brought. But in this instance, Allbirds was able to defeat the case and the class action at the motion to dismiss stage, in part based off of puffery, like I said before, but also because the plaintiff had cited to some documents like, a PETA study and some other like life cycle assessment tools and HIG, MSI, Allbirds was, took advantage of that and cited to those documents in their motion to dismiss and to substantiate their defense. And the key here is that Allbirds had the substantiation in those documents to establish that what they were saying, was not misleading. And the court, in a pretty lengthy opinion, ultimately granted their motion to dismiss. And like I said, since this was the second time around, did not give them leave to amend. The next series of cases I'm going to talk about are the class certification cases. And Trent had highlighted these two in his opening remarks. I promised the last time that I would stop talking about hand sanitizer, which I've been talking about for probably 2.5 years. Well, sorry, just kidding. I have one more hand sanitizer case for everybody's enjoyment. But this was a CBS case that we've been following for some time, and class certification was denied for the second time in this CBS case. Essentially, the court said that the plaintiffs could not establish damages consistent with Comcast. It's a really great opinion out of the Central District of California and a great outcome. And then the other case that Trent also had highlighted is the In Re Fisher Price Rock and Play sleeper. And this is pending out of the Western District of New York. There are several class actions that were consolidated into an MDL proceeding. And this particular opinion deals with the New York consumers only for the that had purchased the Rock and Play between 2009 and the present. And they did certify a class for that. So that's one that we will continue to see what happens. Trent had also mentioned as part of his trends, the personal care products and over-the-counter medicines. And I just wanted to give a couple of examples of, how those are popping up. They're popping up both in terms of your traditional allegations, such as like the first one with the personal care product. Here it's in the Northern District of Illinois. And the allegation is that the defendant allegedly sells a skincare product that is marketed as containing probiotics, but it does not contain probiotics, allegedly, because the ingredients in the material are in a dead state. So that's one way that we're seeing some personal care products litigation, class actions being filed across the country. And the other I'll talk about in a couple more slides, but personal care products are getting hit in the Pfas litigation realm as well. So I'll talk about that, like I said, in a couple slides. The other hot area right now is over-the-counter medicines, particularly cough, cold, and pain patches. So the first case is filed in the Southern District of New York, alleging that the defendant markets its cough suppressants containing DXM as non-drowsy when it's known to actually cause drowsiness. That's a big over-the-counter medicine topic right now, is the non-drowsy. And then another one is also in the Southern District of New York, where the allegation is that the defendants misled in marketing its pain relief patch products, saying that it's maximum strength and will last up to 12 hours, but the patch doesn't stay on for 12 hours. We saw that, in this, since the last webinar to here, it's probably at least 3 different cases that has very similar allegations to that against different defendants. And then greenwashing, I've talked about, in particular with the motion to dismiss stage. But there, and those 2 cases I was talking about, one dealt with the reef safe or reef friendly. Others are dealing with biodegradable and recyclable. And this Earth Island case filed in the California Superior Court for San Mateo has allegations against Clorox and Coca-Cola and others, alleging that those companies had misled the public that its products and packaging had the ability to be recycled And the allegation is that consumers don't have access to the facilities that can actually recycle those products. And that has resulted in the products polluting a local waterway. One of the arguments that was made during the motion to dismiss at the motion to dismiss stage was a personal jurisdiction argument that was denied. And so the case is staying there in California. So that's one that we'll continue to watch. But greenwashing is definitely still a very hot topic. And finally, the biggest area that we've seen the most increase in cases for, which we've predicted now for, gosh, I would say about a year and a half, 2 years, we've been eyeing Pfas litigation and talking about it. Well, it's just really taken off. And since the last webinar we did, which was back in March, the end of March, I guess, there have been 17 new cases filed. And I give two examples here. One is for McDonald's Corporation, filed in the Northern District of Illinois, alleging that McDonald's food products come in packaging that contain high levels of allegedly unsafe PFAS, and that McDonald's allegedly falsely labeled and packaged the packaging and food as safe and sustainable despite PFAS. And then the other example is example cases in the Southern District of New York. And the allegations are that the manufacturer of mascara failed to disclose to consumers that its mascara contained PFAS. So you're seeing a lot of PFAS cases, particularly when you're dealing with trying to waterproof something like waterproof mascara or waterproof food labeling. You also see it with REI got hit with PFAS class action due to some waterproof apparel. So just running down the list of other similar suits, Almay has been sued under a PFAS class action for its mascara. Revlon, L'Oreal has several class actions pending for PFAS and allegations related to its mascara. Clorox has a PFAS case related to Burt's Beeswax chapstick. Nixwear for menstrual underwear. Cava, Burger King, McDonald's, Conagra, they're all food related with PFAS food packaging allegations there. So it's a very, as Trent said, white hot area that plaintiffs are pursuing class actions in. And I think we're going to continue to see more and more companies being sued for PFAS. And with that, I will turn it over to Royce and Kate.
Hey, thanks, Jenny. Yeah, on our end, the PFAS issue is pretty big as well, so really appreciate you bringing that up. Well, so we're going to talk regulatory now, which is kind of changing pace from. And okay, so what are my favorite cocktails or cocktail? I like a Vicaray. It's a classic New Orleans cocktail, rhymes with my last name, Duvernay. Okay. And my favorite song is Let It Go, 1994, Prince. Has a little bit more of a funky jazz vibe to it than other work. And Kate?
Thanks, Royce. So real quickly, I'm a straight bourbon girl, so nothing fancy for me. We've got a fantastic collection at my house if anybody ever wants to come try it. And the song I picked for our theme today, actually, it goes along with one of the topics that Royce and I are going to be talking about with it, which is how FDA has handled the unfortunate baby formula shortage that's been going on. So I lined up my theme with that.
Yeah, that's a huge topic, and we'll get to that in a second. So, what I'm going to talk about kind of first is, what's been going on since we last spoke about, remember how in the last webinar I said, we're expecting all these draft guidances and all of that? Well, we're starting to get them now. in May of 2022, so that's like last month, obviously, FDA came out with one of its like more interesting draft guidances, something that we haven't really seen since the days of DESI or unapproved drugs back in September 2011. It's what I'd call, or Kate and I call, a bit of an amnesty guidance, a guidance where FDA knows that, you know, and look, in my opinion, I believe that a lot of dietary supplement companies, the line between what requires a new dietary ingredient and what is a pre-existing ingredient before DSHEA in 1994 is a toughie, because so many of these ingredients that you're discovering and finding, you know, can literally be found in the plant and were probably there pre-existing DSHEA, but no one specifically mentioned them. So FDA has recognized this and said that, look, you know, looking back at everything since DSHEA, we haven't really seen that many applications for new dietary ingredients. And we know, to use a Southern word, y'all are out there selling them. So we're going to give you a little bit of an amnesty here. And the clock began to run on May 20th. So you have 180 days after May 20th to, another phrase, get right with FDA and submit a new dietary ingredient application for ingredients that you think might actually require one. This is, again, a really tough thing to do because, you know, Kate and I have gone back and forth with clients on whether or not NDIs are required for some things, whether they are required, not, maybe. I would say there are some players out there in the field that definitely know that they're operating when an NDI should probably have been filed. For those folks, I would say, you know, start getting the pack together, take advantage of this 180-day clock. FDA doesn't really add any teeth to this, but we know that the teeth are out there. We know that FDA has taken the time to draft something like this, talking about NDIs, that they're likely starting to get a little bit into the world of maybe we should start doing some compliance. And that this is, again, food, and we flagged last time that, you know, there was a Politico article on FDA talking about food, and this is an example of FDA starting to get a little bit more serious on food. 75 days after submission of your new dietary ingredient, FDA will tell you we got it. No real idea how long it's going to take to evaluate it. But, you know, that might give some degree of protection. Talk to Kate and I for more details on that. But it's strongly encouraged that you do any of this NDI evaluation or whether or not your ingredient requires an NDI, kind of under the approach of counsel or the attorney-client relationship, because some of these discussions can be very complex, very nuanced, and involve, very careful interpretations of law, because you don't want to go through this process and spend all this money unless you have to. I don't think that FDA is going to nab you if you do submit for an NDI. I don't think this is some sort of like, honeypot or anything like that, to use a word from, pirating movies. But it might be grounds for some of your competitors to narc on you. If they've gone through the effort of getting an NDI in there and they believe that their formulation of the product might need an NDI, they might, basically go to FDA and be like, look, we're operating under an NDI. We submitted one properly. Those folks over there did not, FDA. Why don't you take a look at that? And that's exactly what we saw happen back in 2011 when FDA was going after unapproved drugs. Was we saw a bunch of approvals, and then folks who got approved started, and FDA alongside them started going after folks who weren't approved. So just something to think about. Kate, do you want to talk about baby food real quick? Or infant formula,
yeah.
Sorry.
Yes, definitely. Thank you. And, I think just to make one comment on this real quickly, I do think this is going to take some time to develop, but clearly the dietary supplement industry is huge. There's lots of companies out there. So I think it's definitely something to pay attention to and keep an eye on. We may see future litigation related to this as well. And I'll just talk for a moment on FDA's recent guidance on infant formula. This is a obviously very political topic. It's been a difficult one. It's been in the news. We could do an entire webinar on CGMP and manufacturing and supply chain, but we won't touch on that today. But FDA's guidance for the infant formula, I think, is another good example of FDA pivoting fairly quickly during an emergency and putting together a process to try to get these products to consumers as quickly as possible, similar to what it did during COVID. And what FDA did is in May, it put out a guidance document basically saying, okay, in order to get these products out into the market, to try to get them in the hands of folks a little bit quicker, we are going to exercise enforcement discretion on these products, hopefully to allow some of them to be imported. The key things to know is the guidance document, one, puts the enforcement discretion in place until, at this point, November of 2022. FDA lays out the more important things that it'll be focused on as far as enforcement discretion for these products. For example, FDA said in the guidance that if the labeling of the ingredients for the product doesn't exactly match what's required in the regulations, that's something that they might be less concerned about. However, if your product is not meeting FDA guidelines for nutrition content, or there's potentially issues with allergens, that is going to be something that FDA is going to be considering more seriously and will be looking at harder from an enforcement discretion perspective. There is a website available, and FDA is currently listing products that are being allowed to be imported from other countries, Mexico, Germany, the UK, if folks want to look there. And then as far as being involved in trying to get some of these products on the market, FDA lays out very nicely in its guidance the information that needs to be submitted, the name, where it's produced, what facility, and most importantly, and relevant to this, what CGMP compliance is taking place for the product. And I know we don't want to take too much time on this, so we're going to turn into one more of our favorite topics for Royce and I, which is Delta 8. And Royce, I'll turn it over to you to talk about a fairly recent case that's had an interesting opinion, and I think just sort of adds to the tornado of different things that are out there for these types of products.
Yeah, no, absolutely. So, we had an interesting case come out of the Ninth Circuit recently, AK Futures versus Boyd Street. And, this case is not, I say it's a Lanham Act and a trademark case about, two companies having a disagreement over some trademark related issues. But what was interesting and what came out of the case was kind of one of the first major opinings of a federal circuit appellate court on whether or not Delta 8 was part of the Farm Bill or the contemplation of Congress under the Farm Bill. And, this is a complex argument, as they all are. I'm not 100% certain that the court got it right, but it is a court's opinion on it, and it may be referenced by other courts in the future as a starting place on analysis. So essentially, this is what the court said. Boyd argued that Delta 8 is psychoactive substance and illegal. Therefore, USPTO couldn't analyze the issue. And basically went along with the same lines as, the DEA's argument, which is that, the Farm Bill only allowed for hemp and only contemplated the exclusion narrowly of Delta-9 THC below 0.3% as part of that hemp-containing product. It did not contemplate any other cannabinoid or derivative or extraction found within the hemp plant. AK Futures took a different argument, and the court seemed to agree with that argument, which is it's not necessarily that Congress didn't contemplate these other cannabinoids or other THC-type molecules. It's that Congress was very much aware that when it did pass the Farm Bill and it did set a limit of THC content of Delta-9, 0.3%, as long as the final product meets that percentage of containing Delta-9, it was well within Congress's contemplation that other cannabinoids such as Delta-9 would be there, be present, and as long as the Delta-8, but as long as the Delta-9 is below that 0.3%, it's not marijuana. And that's the whole aspect of this, is defining what is or what is not marijuana. DEA takes the position that Delta-8 is psychoactive, and therefore it's either within the definition of marijuana as DEA interprets it, or it falls into another analogous sort of law that accompanied the Controlled Substances Act called the Analogs Act, which basically, the super short version, if it looks like a prohibited molecule and it causes a psychoactive effect for which there is no approved health benefit by FDA, it's likely an analog and likely illegal too. But the Ninth Circuit took the opinion that the determinative factor on whether or not something is or is not marijuana versus hemp is solely the 0.3% Delta-9 THC content. Again, this case was not about what is Delta-8 and whether or not it is legal. It's an IP case. It is not binding authority on any criminal, banking, civil action. It's not going to settle the argument of what is, Delta-8's legality in this country. It's just an interesting opinion from a court on an interpretation of a statute. Maybe other courts interpret it this way, maybe they don't. So in the words of Colorado's former governor, Hickenlooper, on the eve of legalization, don't break out the Cheetos or goldfish too quickly. This is an IP case. Other courts may not follow it. There's still an insane amount of ambiguity. Where Kate and I would normally look is what DEA is doing and what DEA's interpretations are, not necessarily the Ninth Circuit on a case that wasn't really about Delta-8's legality. Kate, I was wondering if you had any other ideas here.
No, thank you. I think this just for me adds to the whiplash on these products. And as we've addressed in a lot of our In the Weeds publications, a lot of states are still saying the product is illegal. So I think the takeaway from this is, despite this case, which I think many will maybe try to hang their hat on, when you're thinking about these products, definitely continue to proceed with caution.
Yeah, certainly. And the last item, and it's not on the slide deck, it's just something that I thought worth mentioning, Kate and I thought worth mentioning, was another draft guidance from FDA. And it's basically FDA has come back and revisited the issue of allergens. And in April of 2022, FDA released a draft guidance on evaluating the public health importance of allergens and other major food allergens. Now, this guidance doesn't really have any enforcement teeth behind it, other than FDA stating in the guidance that it has the ability to consider products mislabeled if they don't properly consider allergens. The guidance is mainly about FDA re-emphasizing its need and the needs of the public to have accurate labels that accurately describe ingredients in order for the public to understand allergens and what allergens are in the product. But what's interesting about the guidance is it also goes into a great amount of detail about how you would evaluate other allergens besides sesame, crawfish, sorry, not crawfish, crustaceans. I guess crawfish are crustaceans. You know, the biggies, dairy, things like that, and where you should be looking if you've got a food and evaluating whether or not there is a large amount of presence of that food as an allergen. You have to list the biggies, but I think what FDA is trying to say in this guidance is think about your product holistically, think about the risk and the number of people affected by a potential allergen out there, and consider whether or not your product is conveying enough information on its label to warn the public about allergen being present. So if there's I think where this guidance is important is it tells us to do kind of a gut check of our labels and, you know, what ingredients we add. Sometimes we make tweaks to labels, make tweaks to products, and whether or not, you know, we may not be listing that specific allergen if it's not the biggies, but whether or not our ingredients and our label and description of the product conveys other information that maybe a smaller subset of people which may have an allergy would use to rely upon. You know, I don't think that any specific enforcement out of the ordinary will come from this. Certainly there will always be the enforcement risk if sesame or soy or others are not listed on labels. But where I think FDA is heading here is that industry overall should be making sure that its labels convey enough information for any consumer to determine if there's an ingredient in there that may cause allergies. So just a reminder, not a significant enforcement type guidance, but more of another, you know, indicator that FDA is again focusing on food safety. And I am turning to my next colleague now. Sorry, there's another slide here. There are other regulatory developments here. Trent, did you want me to go over this?
No, I think we can go ahead and pass it on to Jocelyn in the interest of time, but these are just some other things that you can sort of read or, you know, look into when you have the time. So with that, Jocelyn, do you want to take it away?
Yeah, sure. Okay. Hey, everyone. My name's Jocelyn. I'm in the Raleigh office. And for my updates today, I'll just want to highlight briefly 3 recent decisions from the NAD and also 1 press release. So I know those of you who are on this call are likely familiar with the National Advertising Division of the Better Business Bureau, or NAD, but for those of you who are not, it's been around for a little over 50 years, and their mission is to seek or to monitor and evaluate, really, truth and transparency in advertising. So before I jump into those 3 recent decisions and the press release, I first want to make a confession. I confess that I am a beer and wine drinker when it comes to alcohol, but unlike Jenny, I'm not going to be a contrarian. I'm going to participate in Trent's theme for the day because there is one occasion on which I drink bourbon, and it is when I'm sick. I love a hot toddy. Shout out to my grandma. And I usually make it with the type of bourbon that's in the house because my husband drinks it, which is usually Basil Hayden or Uncle Nearest. And then my favorite song by the late iconic singer, formerly known by a symbol, relates to the gemstones pictured on the right side of the slide. And diamonds and pearls are the perfect segue to my first case that I want to discuss with you all. And so the way cases get to the NAD are usually 3 main ways: from a competitor making a complaint, from an actual consumer, or sometimes the NAD takes up cases on their own. And so this first one was brought by a competitor of Brilliant Earth, Blue Nile. And the complaint was that Brilliant Earth was advertising and promoting free diamond earrings, and they were advertising it as a one-day only special. And Blue Nile was like, those are not diamonds, because they were lab-grown and not natural. And they're saying it wasn't one day only because they noticed that they had run the special several months previous to this. So the NAD recommended, they never actually made a recommendation on this because Brilliant Earth decided to voluntarily and permanently discontinue the offer, and they removed those claims. The next one, again, was brought by a competitor of iHealth, who's the manufacturer of Culturelle IBS Complete Support, Procter & Gamble. And there were 4 separate health-related claims for this one. The main one was that they were arguing that, so the packaging of this Culturelle IBS Complete Support says that it's clinically shown to improve symptoms of irritable bowel syndrome, or IBS. And so to look into this, the NAD evaluated the studies that Culturelle used, they said they used, to show that it clinically shows that it improves these symptoms of IBS. But they said that the study did not really add up. And they said that they recommended that they discontinue these health-related claims, and they did. And the third and final decision that I want to highlight from the NAD is from Cliff Bar, also brought by a competitor, Kind LLC. They're the producers of Kind bars. And the issue here is really interesting and kind of ties back to the topic I discussed last time on our last webinar, which was related to puffery. Because the complaint here is that when you couple the phrase, the ultimate energy bar, with the phrase an optimal blend of protein, fat, and carbs, that it conveys an implied comparative superiority message that has to be supported, that it takes it out of the realm of puffery when you use those phrases together. They said, the NAD said, then it becomes an objectively provable claim requiring substantiation. And the recommendation was for Cliff Bar to discontinue using that challenged claim. And Cliff Bar disagreed, but said, fine, we will cease juxtaposing the 2 phrases. So now when you see these advertisements, it just says the ultimate energy bar without the secondary phrase of an optimal blend of protein, fat, and carbs. So those are the 3 recent decisions from the NAD. But the last thing is this press release that came out recently. It relates to another program of the Better Business Bureau called the National Program's Children's Food and Beverage Advertising Initiative, or CFBAI. And CFBAI is a voluntary participation of the nation's 20 leading food, beverage, and quick-serve restaurant companies, some of who folks are attending this webinar today, so that was pretty cool. But what they decided to do last month, which will be effective January of 2023, was to expand their coverage of advertising in child-directed media to coverage of children under the age of 13, because it was previously under the age of 12. And these participating companies have agreed to only advertise food or beverages that meet the CFBAI's nutrition criteria, or they've decided to not advertise food and beverage on child-directed media at all. And so they've expanded their coverage of that. So the key takeaways from these recent decisions, first is we see an expanded effort to commit to responsible advertising to children, and that's from the CFBAI initiative. We know the importance of not embellishing promotional offers. Don't say they're free diamond earrings if they're not, and don't advertise it as one day only if it's not. And then from the Cliff Bar and Culturelle cases, we know that it's important to consider how a consumer may interpret an advertisement as a whole instead of just pieces and parts of it. And we also are reminded that we should ensure information advertisements can actually be substantiated. And with that, I will turn it over to my colleague, Ben.
Hey everyone, this is Ben Abel. I am an associate in our Charlottesville office, and I'm going to be talking for a few minutes here about updates in food and beverage litigation that we've seen since we talked last. And I will start by saying, first and foremost, that my favorite bourbon beverage is bourbon punch, and specifically the bourbon punch my friend Madison makes that involves many things, but many citrus fruits and teas and muddling, and it's very good. So if you need a good bourbon punch recipe, I can connect you with her. And as for my favorite song by the Minnesotan of the hour, I would say a Little Red Corvette. would be my favorite. Wanted to start out with talking. We often spend most of our time, or at least I do, on packaged goods. Obviously, that's the biggest segment that attends these webinars, and it's the biggest segment when it comes to litigation. But there has been and continues to be litigation when it comes to restaurants and particularly quick service. And in fact, at least anecdotally, if not according to Trent's quant numbers that he actually crunches, we've seen an increase in litigation of this sort targeted at restaurants and quick service, such that it's worth flagging and noting, especially for those of you who either kind of have a quick service or a restaurant SKU or a product, though I will explain in a moment, it also extends to packaged food. So as was discussed earlier, and I won't gild the lily, but so much on PFAS and PFAS litigation, we have seen a number of filings related to PFAS in containers for quick service foods. The 5 here, and I'll note, two of which were filed against Burger King, 3 of which were filed against McDonald's, and then another that was filed against Cava, which is a little interesting, not because Cava is not a big organization, and if we've got one here in Charlottesville, it's sufficiently large, but it is not what you would consider to be a segment leader like the first 2, and so people maybe a little further down the chain here, at least in terms of market cap, should be paying attention. And these suits all allege some version of there is PFAS in the container for the food at the restaurant, often to act as to keep grease in and keep your hands from getting greasy or what have you. And that conflicts with some kind of statement that the restaurant makes, whether it be about, in terms of Burger King, our food is 100% everything you want, nothing you don't, or claims on a company website about food safety. Basically, some affirmative statement that is misleading if the product contains PFAS. We will see what happens to these, and in fact, I'll tease that Trent, Ginny, and I have an article that will be forthcoming at some point on PFAS in the quick service industry. So check your emails and your LinkedIn profiles to see when that comes out. But we've also seen litigation around food size and kind of the food appearance. The first here, Chimienti, I'm sorry if I mispronounced that, and Wendy's has an interesting bent in the sense that Wendy's and McDonald's were sued within the same complaint. You typically don't get a twofer on different companies completely divorced from each other, not siblings or parts of the same corporate structure sued. But those have said basically, Wendy's says it's selling you one sized product, McDonald's says it's selling you one sized product, and you're getting another. And the complaint is full of pictures of here's what Wendy says their Dave's single burger looks like, and here is the much less exotic looking, not a picture taken in the studio of the burger I actually received at the drive-thru window. A similar suit was filed against Burger King. Again, the same type of allegation that you told me you were giving me one thing and you were giving me another. These claims, while we'll talk in a moment, have not typically gone well for plaintiffs in the quick service industry. Notably, last year, Smashburger, however, settled a series of lawsuits for $5.5 million. And if you take a look at the advertisement on the slide, part of that claim was this statement, triple the cheese, double the beef, and things like it for the triple double burger, led consumers to believe they were getting double the meat, except plaintiffs alleged that there were double the patties, perhaps, but in fact, the patties were half the size of the typical Smashburger patty, and so it was 2 times 1/2, which I can do lawyer math and say ends up being the same amount of meat. And so the claim that you were getting double the beef, in fact, was not true and was half as true. That is different than what I think is happening in some of these other suits, in that, for instance, I think most of us would know if you buy a quarter-pound burger at a quick-service restaurant, you know a quarter-pound is calculated prior to cooking, and so there is some inherent cooking off of the product as it's actually on the grill or on the griddle, what have you. That's a not negligible, but relatively small thing we all anticipate, as opposed to Smashburger that said, nope, you just in half. This is not an issue of you cooking the burgers and they get smaller as the fat cooks off. This is just half as much meat. And so I think that was a substantial difference between these other claims, which are, you're not giving me, a quarter pound on the number that I was expecting, or as much lettuce as I was expecting. We have seen some of these cases continue to go manufacturers or QSR's way. So, for instance, the Subway lawsuit regarding its tuna subs, this is, for whatever reason, one of those suits that the national zeitgeist just takes off on. The allegation being that Subway's tuna salad subs don't contain any tuna. And I think at one point the complaint said contain anything but tuna. The first amended complaint was dismissed in that plaintiffs did not allege that with particularity the specific labeling statements that said that this was 100% tuna. So that, again, is a good reminder. Are you in Rule 8A or Rule 9B when it comes to the complaint to which you're responding? And the Williams case was about a plant-based burger that allegedly Burger King was advertising as, I think it was the Impossible Whopper, was advertising as being 100% plant-based, no meat, whatever. And plaintiffs allege, well, it was being cooked on the same grill or griddle that was the regular burger was being cooked on. There was some transfer from the regular Whoppers to these Whoppers, and as a result, it wasn't actually 100%. And what the court said is, you got what you paid for. You got a plant-based patty. There was no part of any of this that said that anything other than the patty was going to not be meat. And that a reasonable consumer basically expects for some kind of transfer in a kitchen of that size at a quick service restaurant to happen. All of that is to say that this stuff is out there. It continues to be out there. And it's important not just for those in the restaurant quick service industries. For instance, on Pfas litigation, Conagra got sued with two separate lawsuits regarding various popcorn SKUs that it has, that its popcorn bags contain PFAS in them. And so almost in the way that like Prop 65 that Alicia will talk to us about in a few minutes, it clearly is becoming as if there is anything in any container related to food, the allegation is going to be that those PFAS, those chemicals transfer over into the food, whether it's packaged or a restaurant product, and give rise to a cause of action. The next one I wanted to talk about is Made in the USA and Geographic claims. Some of this is based on some recent developments, but also there's been a couple of instances recently working on matters where there seems to be some lack of clarity on Made in the USA claims and how to make them and what can be said or not said. And so I'll start with the relevant players here. The first is the first tranche of players are USDA, FDA, TTB, I'll add as well, that's not here. If you're a USDA regulated entity, there are specific regulations that you can look up that give you when you can make a Made in the USA claim, or if you have to make some other kind of geographic claim. So as with many things in the USDA world, that is governed by regulation and provides something of a rule book. FDA, by contrast, has the Food, Drug, Cosmetics Act, but largely has its hands off in this area. It doesn't have any specific regulations related to Made in the USA claims, but instead defers to FTC and also Customs and Border Patrol and says, do the things that they tell you to do. And if you don't follow Customs and Border Patrol or FTC's regulations on this, you might also be violating the Food, Drug, and Cosmetic Act by making a materially misleading statement on your labels. Customs and Border Patrol I didn't put on here because it doesn't really relate to the Made in USA claim, but Customs and Border Patrol obviously has specific regulations when it comes to importing a product. So if you're importing something into the country and then putting it in a product, you need to pay attention to CBP. FTC really takes the lead on Made in the USA, and we'll talk about that in a moment. Two other players here. California has a specific Made in the USA statute that we'll talk about in a moment. But if you are going to sell a product in California, as I suspect many of you are, because 1 in 8 Americans lives in California, it's a pretty darn important market to make money in. If you are going to sell a product in California and you are not otherwise regulated by a federal regulator like USDA that gives you specific guidance, the California Made in the USA statute also applies to you. And then finally, there are private plaintiff claims. There are Lanham Act claims that are potentially brought by competitors. All of those factor into this. So the two types of Made in the USA claims are both qualified and unqualified Made in the USA claims. An unqualified Made in the USA claim just says Made in the USA or language to that effect, without any qualification, without anything else, Made in the USA. And what FTC says is to make such an unqualified claim, all or virtually all of the product and its constituent ingredients or parts need to be sourced from within the United States. Obviously, there is some imprecision in what all or virtually all means. California is helpful for that, and we'll talk about that in a moment. But unless all or virtually all of not only the product, the processing of the product, but also the ingredients that are used in the product come from the United States, a product should not make an unqualified Made in the USA claim. And while it might be better than just Made in the USA, if you said, for instance, just brewed in the USA without any other qualifier, FTC is likely going to take the position that still is an unqualified claim because you haven't talked about the ingredients themselves. And so if you were trying to just say, well, this is the part of the process we do, just processed in the USA without anything more, that still would be unqualified, which probably falls within the all or virtually all requirement. By contrast, a qualified claim is one that says processed in the U.S. from internationally sourced ingredients, manufactured in the United States from internationally and domestically sourced ingredients. And that claim is allowed provided that whatever you are saying is true. So if you actually brew your product in the United States, then you can say that even if it's got internationally sourced ingredients, as long as that's correct. California both has a more exacting, for lack of a better term, but at least provides a number. California says to make an unqualified Made in the USA claim, you need to have 5%. You are allowed, 5% of the product's ingredients to come from outside the United States. That goes up to 10% if the ingredient or ingredients are things that are not found within the United States. So nickel or whatever rare metals that might go into a product that just are not found in the United States in sufficient quantity, that gives you a 10% threshold. But 5% otherwise of your product needs to come from outside the United States. Otherwise, you need to make a qualified claim. And there has been litigation around this. For instance, Tabasco settled a Made in the USA claim for $650,000, which compared to some of the other dollar amounts we've talked about isn't as large, but that's real money. And also, as you can see on the right side here, that, there was a minor but important labeling change in that the old Tabasco logo, which made the Made in the USA claim on the PDP, Made in the USA claim came off. The rest of the logo otherwise tax for our IP friends. But there was a substantial labeling claim, albeit small, that happened there. I'll mention that beef and pork continue to have different rules in this area as a result of a dispute with the World Trade Organization. That was seen in a case we actually talked about last time, the Thornton versus Tyson Foods case, where made in the USA claims on beef products were challenged because the cattle allegedly was not born or raised in the United States, but was slaughtered and processed in the United States. And under current rules, beef and pork do not have to make any country of origin labeling claim. And to the extent that USDA approves a label that says in the Made in the USA, and subject to what the Ninth Circuit told us last time about the burdens on proving preemption, that's good enough. More generally, outside of Made in the USA continues to be an issue. For instance, Kona Coffee, there are a pair of suits, both from consumers and coffee growers actually in the Kona region of Hawaii, who have sued coffee makers for selling Kona coffee that they allege doesn't actually come from beans raised in, grown in the Kona region of Hawaii. Some of those have been settled for $13.1 million. And so we've talked at length on a number of these about different geographic claims and the types of claims you can or can't make. But getting it allegedly wrong, at least, can have a steep price tag. And finally, I just wanted to provide some quick updates on things other than 12b6. We often talk a lot about claims on that relate to a motion to dismiss. That's kind of the big thing. Is this going to cost a lot of money or less money? Well, are you going to survive a motion to dismiss or not? But it's not just that. For instance, we've seen motion for summary judgment. Motion for summary judgment was partially granted in the body armor suits after some pretty bad deposition testimony from the named plaintiffs in those cases, who were making a sugar claim that they didn't know that body armor, which is a sports drink, was not as healthy for them as they believed. But they also said they've always known that sports drinks, of this type contain sugar, and they knew that body armor was a sports drink. So by the transitive property, they knew that there was sugar in the drink, and so they couldn't support a lot of their claims. We've also, in Trent, talked about this. We've seen a number of class cert denials. For instance, in the Gross v. Valor case, the court in that case denied cert and basically said the survey data that plaintiff attempted to rely on was not good enough to support class cert. And the anecdotal evidence of consumer confusion that named plaintiffs themselves provided wasn't sufficient to support a class-wide allegation. And so I think the lesson being, take a look at the survey data and actually challenge it if you're at the class cert stage, because I think increasingly, though again, Trent's numbers may or may not bear this out, courts are taking a hard look at survey data and not just buying whatever the plaintiff is selling them. Trent talked about the joint juice verdict that we got earlier. That was preceded by an unsuccessful motion to decertify the class, which may have been a bit of a canary in the coal mine. I will add that part of that was the plaintiffs proceeded not just on a price premium theory, which is what we always talk about, but on a full refund theory, because they argued, well, if joint juice doesn't help my joints, it is literally worthless. It is not vanilla ice cream that may not have natural vanilla, but sure, it does taste good and it does taste like vanilla, so there's just this price premium issue. There, the allegation was, if it doesn't help my joints, it does nothing, and so I should get my entire amount of money back. And finally, Alicia will talk to us here in a moment about injunctive relief, but the injunctive relief remains alive and well, and especially in the Prop 65. Alicia will talk to us about Prop 65. It remains alive and well, and Prop 65 continues to be enjoined on a number of different chemicals and substances. With that, I will pass it off to Maggie Bowman to talk about a much happier topic, which is alcohol.
Hi, everyone. Again, my name is Maggie Bowman. I'm here in the Richmond office, and I'm the cool kid at the party because I brought the alcohol. So on that note, this is my favorite bourbon. I don't have a favorite bourbon cocktail like Kate. I prefer it straight, and I'm not sure. It might just be that I'm too lazy to mix up different things, and I just want to pour liquid into a glass, but there it is. I don't think I added that. Anyway, my favorite song by the artist of the hour is, I'm a product of the 80s, and so my first introduction to this artist was was, of course, Julia Roberts singing Kiss in the bathtub in Pretty Woman. So that's got to be the original's got to be my favorite. First, what I'm going to talk about is a TTB notice that they just issued a couple weeks ago related to the standards for fill for wine and distilled spirits. So they have proposed some amendments to the regulations that currently exist about what the standards are for fill for those two types of alcoholic beverages. It's I think, a pro-business, pro-consumer proposal that they've made here. And essentially the regulations that exist right now as to the fill standards for wine and distilled spirits are very specific. So there's something like a dozen very specific sizes of containers that you can sell alcohol, well, wine and distilled spirits in the United States. Like, you can't have a 753 milliliter bottle of wine. It's got to be 750. And in 2019, TTB issued a notice and said, let's get some comments on whether this is a good idea, whether we need to be revising this. And they've actually got a number of comments, most notably from trade groups, governmental agencies, and companies from around the world. So the reason that all of these international commenters are providing input is because, of course, standards are not all the same. So just as an example, there's a South African importer who provided a comment. So one of the appropriate standards right now is a 335 milliliters. You can sell wine or distilled spirits in 335 milliliters. But in South Africa, the standard can size is 330 milliliters. So this South African importer can't have its wine or distilled spirits canned in South Africa and then imported into the United States. It's got to do this whole rigmarole to get the appropriate size cans into the United States. And so they've provided a comment. Let's look into a different, let's add 330 milliliters to the standard. So, TTB has compiled all of these comments, and it's proposing one of two changes. So either they're saying, what we'll do is we'll take all of these comments that we've gotten and we'll just include all of those new standard numbers in the list that we allow. Alternately, we'll just erase it altogether. We'll say there are no standard sizes that we're requiring from wine or distilled spirit manufacturers, and instead we'll just have a minimum for wine and for distilled spirits. This is a 250 milliliter can of my sparkling green tea from Trader Joe's, and so they're proposing that the minimum would be about 50 milliliters, essentially so that they can ensure that there's a sufficient label on there to represent what's in the can. And then no maximum for wine, and there would be a maximum of something like 3.875 milliliters, or liters, for distilled spirits. So comments are due in July, and we'll just be watching this to see what they do. We don't have any way of knowing which way they'll go, but I think it certainly would be cleanest and simplest if they did away with all of this list of standards altogether. Next, I just want to talk about a couple cases that we have seen come through the pipeline. Trent had mentioned that our good friend Spencer Sheehan has slowed down, but it seems that he has developed an interest in some alcohol cases. And so I think we really want to be watching Spencer Sheehan for these alcohol cases, and I'm going to talk about two today. So the first up is Brown v. Zamora. Zamora makes a super premium rum under the Don Papa brand. And you can see here that we've got the front label. It shows that it says it's aged in oak, and the back label is quite romantic. It says it's aged for up to 7 years in oak barrels, the foothills of this mountain in the Philippines, before being blended to perfection. So Plaintiffs, and by the way, this complaint was just filed in the Northern District of Illinois on May 22nd. They filed an amended complaint just a couple days ago. So we have not seen, obviously, any motions practice, but I anticipate we will. The allegations are the factual allegations can be grouped into sort of two areas. So first, plaintiffs are saying that this doesn't qualify as rum because there are additives like vanillin, glycerin, added sugars, and the regulations require a certain percentage of the product to be rum, of course, and plaintiffs are alleging that they've gotten all of these bottles and they've tested them and the additives exceed the allowable amount of additives. And so they're saying this should be marketed as imitation rum. And the second claim, of course, relates to the aging. Plaintiffs allege that the aging claim is misleading because in reality, it's a mix of younger and older rums with very little of the rum being actually 7 years old. And plaintiffs are saying that the way that they phrase this, that it's aged up to 7 years, leads the consumer to think that that the blended rum would be very close to or equal to 7 years in age, but it's not. So again, we'll be watching this. Plaintiffs have brought a lot of fantastic. Yes.
Sorry to interrupt. We're running short of time. If you could wrap up in the next 30 seconds so we can hand it over to Alicia, that'd be great.
Oh, sure. Absolutely. The other case that we're watching is a hard kombucha and hard seltzer case. If anybody that's been down any of these grocery aisles is probably seeing a ton of seltzers and kombuchas. There's several cases like this that we're watching. And this is also Spencer Sheehan. He seems to have a real problem with alcohol advertising that it has any health benefits like antioxidants. So I think we're really going to be watching this kind of case. Thanks, Trent.
Hi, everyone. This is Alicia, and I'm in the LA office for McGuireWoods. So here today to talk to you a bit about what's going on in Prop 65 world out here in California. And before we jump into that, first off, going with the theme, my favorite bourbon cocktail is an apple bourbon Manhattan, which is a Manhattan, which I'm partial to begin with because I'm from New York originally. And then obviously with bourbon rather than rye. And instead of doing simple syrup, you put some apple cider in there. And it is so delicious, especially in fall. This is a cocktail I love so much that I'm going to be having it as the specialty cocktail at my wedding this October. So highly recommend trying that one. And then jumping into a couple updates here on Prop 65. So first off, we have some updates on the changes to short form warnings that were proposed back in January of 2021. You probably remember that OWIHA had proposed changes to short form warning requirements. And we had just announced that they were actually unable to complete the rulemaking process on the short form warnings within the statutory period. That period where they're allowed to complete it is 1 year from the notice of the proposed regulation. And at this point, there's also a 4-month extension period for the state of emergency during the pandemic. And unfortunately, they were unable to meet that deadline, which was just in May, and they announced on May 20th of this year that they're going to just allow that rulemaking to lapse and plan to restart the rulemaking process within the next few weeks. This could be any day now because, of course, that was already a few weeks ago. And there will also be a new notice and comment period required. They'll have to start the process completely over again. So if you were unable to make comments and would like to, or for other people who are lobbying for changes, which there have been a good number of changes already, you will now have an additional opportunity to do that. And one other update on the short form warning changes is that back in April, just after our previous March webinar, OEHA also announced 2 significant modifications to that proposed amendment. The first one is that they revised the effective date. So now it will apply to products that are manufactured 2 years from the date that the Office of Administrative Law adopts the new regulation. That was previously just 1 year from the date of manufacture. And again, that clock doesn't start ticking until OAL actually adopts the regulation, which is now a long way off. And the second modification made in April was that OEHA has allowed for use of short form warnings on labels of any size. You may remember they had previously limited the use of short form warnings only to certain small labels where a longer warning wouldn't be able to fit as easily, but that was completely removed, at least in the latest modifications. Again, they're restarting the process, but they also have indicated that they plan to continue from where they left off. So I think it's fair to anticipate that those 2 changes are likely going to remain for the future. The main takeaway here is that assuming OEHA sticks with this 2-year from date of manufacture implementation period in the latest amendment proposed in April, the new rule is not going to go into effect any sooner than 3 years from when this rulemaking process restarts. It has not restarted yet, so at least 3 years, more than 3 years, we can say safely from today until you can expect this to affect manufacture of products. One other update in a case that we've been talking about a lot is on the California Chamber of Commerce v. Bonta, the Attorney General here in California. This case is pending in the Eastern District as well as the Ninth Circuit. So on March 17th, the Ninth Circuit affirmed the U.S. District Court rulings. As a refresher, this means that the Ninth Circuit held, just like the Eastern District held, that Prop 65's warning requirements for acrylamide in food and beverage products likely violates the First Amendment. And they also affirmed the preliminary injunction that was stayed at that point that is now enjoining lawsuits for failure to warn from acrylamide in food and beverage products. Those lawsuits cannot be filed at this point. The Ninth Circuit, just like the Eastern District, pointed to a lack of scientific evidence showing that acrylamide does cause cancer in humans, meaning that Prop 65 is compelling false speech when it requires companies to warn that acrylamide is, quote, known to the state of California to cause cancer. As I'm sure everyone's well aware, is that standard safe harbor warning language. The intervener in the case, Council for Education and Research on Toxins, commonly referred to as Cert, had appealed, and now they are also requesting a rehearing in bank. And the Ninth Circuit has at least entertained that request. Those are very unlikely to be granted typically, but the Ninth Circuit did ask Cal Chamber to provide a response to Cert's petition. So that will be the next step in that case. And what will happen after that is that the ruling is not yet final. It won't be final until the Ninth Circuit issues a mandate, which they haven't done yet, and will not be until sometime after they decide the rehearing petition. And the big takeaway, though, today is that this Ninth Circuit ruling on constitutionality of Prop 65, warnings related to acrylamide contained in food and beverage products, is now the first appellate decision on the First Amendment versus Prop 65 issue. Now, we've seen that issue in the glyphosate cases as well, but that is stayed in the Ninth Circuit. So this is the first ruling we've had. If this ruling becomes final, it will have far-reaching consequences for Prop 65 enforcement and litigation, particularly for listed chemicals where there's an argument that there's disagreement in the scientific community about whether that chemical actually causes cancer in humans. So finally, just to wrap things up, with the theme at the very end, my favorite song from the artist that we're not allowed to say for trademark reasons is 1999, which is just super fun song I've always loved. So with that, I'll pass it back to Trent. I know we're running short on time, but maybe he can wrap it up for us or answer any final questions.
Yep, thanks a lot, Alicia, and thanks to all of our panelists. Thanks to all of our audience members. Really appreciate y'all attending here today. Feel free to reach out to us with any questions or you want to discuss any of this. Thanks so much for attending today.